Hi, my name is Marta Siemiarczuk, and I'm a family law lawyer with Nelligan O'Brien Payne in Ottawa. People commonly think that when they have a family law dispute or an issue come up, if they call a lawyer, it means they're going to court. So I'm here to tell you that that's not necessarily the case. And the purpose of this video is to outline some other dispute resolution options that are available to people who find themselves with a family law problem. There are three primary dispute resolution options available, those being mediation, collaborative family law, and private arbitration. Mediation entails utilizing the services of a third-party neutral facilitator to lead a negotiation between disputing parties. A mediator is typically another lawyer or sometimes another professional, such as a financial professional or a mental health professional, that will help parties to work through the dispute and reach an agreement amongst themselves. Mediation can be conducted with or without your own lawyers, although in the normal course, if you do attend mediation without a lawyer, it's probably best to seek some legal advice afterwards or throughout the process in the background to make sure that you're covering things that need to be covered and addressing them in a way that will work for the long term. Provided that both parties want to resolve their dispute, mediation can be an extremely effective process to use and a great alternative to going to court. Collaborative family law is also an alternative way to conduct a negotiation between parties with a family law dispute. The collaborative law process requires both parties to retain their own individual lawyers who are trained and certified to practice collaborative family law, such as myself. And the two lawyers essentially work together to co-mediate the negotiation while at the same time providing their own respective clients with independent legal advice throughout the process. Collaborative family law is always a completely confidential process. And it's also based on the premise of full and complete disclosure of relevant information that would impact the agreement. So if one party isn't sharing the necessary information, then the process will end. The primary principle and foundation of collaborative family law is you sign an agreement that you will not go to court during the process. So at any point in time, if either party threatens to go to court, then the process stops and both people have to retain new lawyers. A collaborative negotiation is done through a series of four-way meetings comprised of the two individuals and the respective lawyers. Everything is done around a table. And the discussion is open between both sides throughout. Last but not least, there's private arbitration. Arbitration involves retaining the services of an independent third party to make a binding decision regarding your dispute. In order to proceed with an arbitration, the two parties have to choose an arbitrator, sign an arbitration agreement, which sets out the arbitrator's mandate, and agree that they will follow the decision made by the arbitrator. In an arbitration process, the parties will attend a hearing before the arbitrator where they're given the opportunity to present their evidence and documents supporting their case. However, unlike a court process, an arbitration can be much more informal. The parties decide how formal or informal their process is going to be. It's held outside of a courtroom. It's typically in a boardroom. And the process, again, is confidential. So all of your information doesn't make it into the public record the way it would in a court process. Depending on the circumstances of your family law problem, arbitration can be a very effective and efficient dispute resolution mechanism. It can quite often be less costly than a court process, and you'll typically, again, depending on the circumstances, get a decision much more quickly than you would in the court system. Now, while I've discussed various options to going to court, people should recognize that at all times, regardless of what kind of dispute resolution process you've been using, whether it's mediation, collaborative law, arbitration, or court, you can still negotiate between yourselves and reach your own agreement. There's nothing that ever precludes that from happening. Before deciding on a specific process to use, you should certainly seek the advice of a family law lawyer who can give you some more information about all of these processes and other alternatives. And they can help guide you in picking the most appropriate dispute resolution mechanism for your particular situation. The circumstances of each family law problem and each family will always differ. And so it's important to really give some thought as to what type of dispute resolution process is going to be best for you and work to resolve your problem in the most efficient and cost-effective manner. If you want any more information about these or other options, you can visit our website at www.nelligan.ca.